This week, we begin our consideration of certain of the factors and events in our history which brought freedom to the edge. Today, we'll discuss two of these events, the Alien and Sedition Acts of 1798 and the suspension of the writ of Habeas Corpus in 1861 at the outbreak of the Civil War and immediately following. If the 1770s and 1780s were the best of times in Dickens' phraseology, 1798 and 1861 were surely among the worst of times. Now, first to the year 1798 and the Alien and Sedition Acts. In order to understand the passage of such a drastic departure from the letter and spirit of our founding documents as the Alien and Sedition Acts, it's necessary to explore in some detail the atmosphere prevailing in our country in the year 1798. The party system was just in its infancy. Washington, in his farewell address, had pleaded to the body politic to avoid the party system at the risk of destroying the Union. But nonetheless, two parties had emerged, namely the Federalists and the Republicans, each with a distinctly different agenda. President John Adams was a Federalist. His Vice President, Thomas Jefferson, was a Republican. In those days, the Constitution was so structured that that could happen. Federalists generally favored strong federal government, and they favored England over France. The two were at war. Republicans were essentially the anti-Federalists during the debates over the Constitution. They were champions of states' rights and, in general, were more sympathetic to the French cause than that of the English. In the year 1798, there was a major threat of war with France looming over the former colonies. At least that was the perception. And there was much to back up that perception. General Napoleon Bonaparte was marching through Austria and Italy virtually unopposed, seemingly invincible. The French Directory had already announced its intention to seize all neutral ships carrying goods made in England. In this atmosphere of uncertainty, President John Adams sent 3 envoys to Paris to seek peace with the French, including Eldridge Gerry, a very good friend of Adams, and a man who was nonetheless known to be sympathetic to the French cause. The 3 attempted to arrange a meeting with Talleyrand, the French foreign minister, who was then effectively in charge of the Directory. But they were rebuffed in what came to be known as the X, Y, and Z affair. 3 so-called French ministers, envoys of Talleyrand, approached the Americans in private. Monsieur X demanded a douceur, a bribe, in the amount of $25,000 for Talleyrand personally. Monsieur Y demanded a $6 million loan to France, and Eldridge Gerry pointed out that such open support of the French by the former colonies would infuriate the British. Monsieur Z proposed a convoluted scheme which involved the purchase by Adams' committee of Dutch bonds, which would eventually wind up in French coffers after a long trail of intrigue and cover-up. It was an affront to the former colonies. Now, Adams was determined to maintain a policy of neutrality. And when word of this XYZ affair reached him, he initially tried to suppress it. But news traveled fast in the former colonies, and soon the news of the XYZ affair leaked out. It immediately raised a storm in this country. The rallying cry against the French, a slogan shouted by Representative Harper on the floor of the House, instantly became famous. Most of you probably know it. Millions for defense, but not 1 cent for tribute. Now, unlike George Washington, who preceded him in office, Adams was not immensely popular. He had no loyal following, no coterie of friends in Congress. Further, there was looming danger, and America had little military strength on land or on sea. With the blessing of the French Directory, French privateers were now preying on American merchant fleet at will, and there was no way to stop them. Our country began to prepare for war. Congress passed measures to arm our merchant ships, but the lumbering merchantmen were no match for the French corsairs. Funds were appropriated now for harbor fortifications, cannon foundries. And in May 1798, Congress passed a bill empowering American warships to capture any French privateer found in American waters. And then Congress appropriated funds for a provisional army and a Department of the Navy. Now, U.S. naval strength had always been close to the heart of Adams, who had personally felt the sting of French corsairs. In his second perilous voyage from America to Europe as an American ambassador, there's a vivid description of this harrowing voyage of Adams and his son John Quincy and McCullough's Adams, which I commend to those of you who haven't read it. It's a wonderful story and great bravery. Amidst all of this uncertainty and angst, Adams recalled a reluctant George Washington out of retirement to head up the Army. Now, Washington insisted on commissioning Alexander Hamilton as his second in command. Hamilton, although a Federalist, was no favorite of Adams. The president, like many others in administration, considered Hamilton an opportunist, lusting after power, both military and political. Unfortunately for Adams, Washington by this time had aged considerably, and he relied upon the younger Hamilton to organize his command. He insisted on the appointment, and Adams reluctantly agreed, placing Hamilton, a much-feared high Federalist, in virtual command of the Army, to the consternation of the Republicans and of many moderate Federalists as well. Many of them feared that Hamilton, left to his own devices and in control of the Army, would lead a march on the Florida and Louisiana territories then held by Spain and immediately precipitate a war. And there was xenophobia aplenty. There had been a mass influx of French citizens into this country. There were now over 25,000 French emigres here. Many were French aristocrats escaping from the excesses of the French Revolution. But there had also been substantial immigration from San Domingo, where the slave rebellion of Toussaint de Louverture had sent many French fleeing for their lives. There were French newspapers, booksellers, coffee houses, clubs, boarding houses, brothels, and of course, French restaurants. Wild rumors began to sweep the country. It was rumored that France had already declared war on the United States, and the French were moving to take possession of Florida and Louisiana. There were accusations in Congress and the Federalist press that French emigres were plotting to overthrow our government. In addition to paranoia about the French, there was fear of the so-called Wild Irish, refugees from the Irish Rebellion of 1798 who were thought to include radicals. In any case, because of their anti-British sentiment, many Irish immigrants gladly joined the ranks of the Republicans. One such Irish refugee, named Matt Lyon, now a representative of Vermont, was accused on the floor of the House of plotting to overthrow the government. He spat upon his accuser, a Federalist representative from Connecticut, whereupon a battle royal ensued right on the floor of the House with a cane and fire tongs. Well, incidents such as these and the general atmosphere of xenophobia that pervaded the country set the stage for the passage of the Alien Acts. These acts greatly increased the residence requirement to obtain citizenship from 5 to 14 years. And perhaps more importantly, they effectively gave the executive unrestrained power to deport aliens, causing a blatant imbalance in the separation of powers. And what then about the press? Newspapers had now become a major factor in the party wars and in the debates over domestic and foreign policy. The principal Republican paper was called the Aurora. The principal Federalist paper was called Porcupine's Gazette. And they were at war with one another. The Aurora taunted Adams and the Federalists. The Porcupine Gazette accused the Republicans of conspiring with French agents to abuse and misrepresent the president, and of attempting to force his resignation so that they could gain power under the reign of then Vice President Jefferson. Now, Jefferson was a Republican and allegedly a lover of the French Revolution. At the same time, Alexander Hamilton was writing articles in the Federalist press under the pseudonym Marcellus, which Republicans alleged were merely attempts at intellectual justification of the emotional anti-immigrant outbursts of the mobs. As the tension mounted, street fights broke out between rival gangs, some wearing the red, white, and blue cockade of the French Revolution, others wearing the black cockade of the American Revolution. Benjamin Bache, the Republican editor of the Aurora, was in constant danger. His house was assaulted. It was rumored that French agents were plotting to burn the city. At the presidential mansion, John Adams, not an alarmist, finally consented to have a sentry posted at the door. All of this, plus an extraordinary affair involving Alexander Hamilton, exposed by the notorious journalist James Callender, who was himself a fugitive from the Scottish sedition law, and who wrote for the Aurora, and who pioneered the public exposure by the press of men in power, set the stage for the Sedition Acts, which were passed almost immediately after the Alien Act in 1798. Well, believe me, Clinton and Lewinsky was no juicier than the affair of Alexander Hamilton and Maria Reynolds. There was intrigue piled upon intrigue. Central to the story was Maria Reynolds, a curvaceous brunette with radiant blue eyes who bedazzled Hamilton. Now, Hamilton was a notorious ladies' man, a very married notorious ladies' man. James Reynolds, Maria's husband, was an admitted scoundrel. A ne'er-do-well from New York had named Reynolds in a scheme to buy up claims for past wages from impoverished Revolutionary War veterans at a time when Hamilton, who was Secretary of the Treasury, was developing a plan to have the federal government assume the debts and pay them in full, 100 cents on the dollar, which he did, by the way. Up to that time, these debts had been the obligations of the several states. Regrettably, most of the state treasuries were broke, and the currencies were so weak that many of the old veterans had been selling their claims for 10 cents on the dollar. Well, speculators such as Reynolds, who was a bum, were secretly obtaining lists of these veterans and the amounts they were owed. Reynolds, in fact, had been caught red-handed impersonating one of these veterans and had been jailed. Unfortunately, Hamilton had been spotted giving money to Reynolds. It was thought by some that Hamilton was conspiring with Reynolds in the purchase of the claims and the divulging of lists. All of this, however, occurred in 1792, 6 years before the Alien and Sedition Acts. So what effect did the Reynolds affair have on the passage of the Alien Sedition Acts 6 years later? Well, back in 1792, James Monroe, a Republican, and Frederick Muhlenberg, Speaker of the House and a Federalist, having been informed of the circulation of these rumors about George Washington, Secretary of the Treasury, were delegated to confront Hamilton with the accusations in private. No one, it seemed, was anxious to see a scandal erupt during the administration of the revered General Washington. So they confronted Hamilton in private. Hamilton's explanation to Monroe and Muhlenberg was the stuff of pulp fiction. He explained that the comely Mrs. Reynolds had approached him one evening in his home when his wife was away. She explained to him that she approached him because he was an acquaintance of her husband, and she was a damsel in deep distress. Reynolds, the scoundrel, had left her penniless, and he was nowhere to be found. She and her small child needed money for transportation to her parents' home in Massachusetts, where they could find food and shelter. The fair Maria desperately needed $30. Hamilton said, "Not here, my dear," or words to that effect. Let your imagination wander. You can fill in the blanks. She said, "Well, maybe my place later tonight," or words to that effect. Being a macho fellow, willing and eager to help a damsel in distress, Hamilton naturally appeared at her apartment later that night. She greeted him in a very low-cut gown, and it seems they exchanged more than just $30. Well, according to Hamilton, Reynolds, the blackguard, not only found out about the affair, but as Hamilton alleged, he had no doubt planned it. And now Reynolds was blackmailing Hamilton, a married man of public stature. Well, that's why Hamilton was seen giving money to Reynolds. At least that's what Hamilton told congressional delegation of Muhlenberg and Monroe back in private in 1792. Now, having an affair was indeed scandalous, but as we all now know from Clint Lewinsky, an affair in and of itself is hardly a crime against government. Monroe and Muhlenberg, being gentlemen, promised not to make any of this information public. And indeed, being gentlemen of honor, they kept their word. And thus the scandal had lain dormant for 6 years, until word of it was leaked allegedly by Thomas Jefferson through his colleague, the scandalmonger James Callender. Now, Jefferson apparently worked behind the scenes a great deal. Callender, of course, went public with the story, printing it in the Aurora, and then all hell broke loose. Hamilton, by 1798, the most powerful Federalist in the country outside of Adams, accused Callender of libeling him. But to mount a defense against the accusation regarding his meetings with James Reynolds, Hamilton found it necessary to go public with information about his unfortunate affair with Miss Reynolds. The scandal would kill forever Hamilton's chances of running for president or serving in any administration again. But it would also result in the Federalist press, which Hamilton controlled, calling for laws to prevent scurrilous attacks such as these by the press on government officials in the future. Well, in this atmosphere of pending war, suspicion and sex scandals, and malicious accusations in the press, The Alien Act was passed in July 6, 1798, the Sedition Act, severely limiting a free press almost immediately thereafter on July 14th. You must understand that Congress was in a hurry to adjourn and get out of Philadelphia. It was the middle of the summer, and there was a yellow fever epidemic that seemed to plague Philadelphia every summer. It was rampant in the capital, and they were anxious to get out. Now, the Alien Act, called an act respecting alien enemies, provided that whenever there shall be declared a war between the United States and any foreign nation, or any invasion or predatory incursion shall be perpetrated, attempted, or threatened against the territory of the United States by any nation or foreign government, all citizens, aliens, or subjects of the hostile nation or government could be apprehended, restrained, or removed. They're also provided that the president could, without any restraint from any branch of government, by proclamation or other act, direct the conduct to be observed on the part of the United States towards such aliens, and the manner and degree of restraint to which they shall be subjected. In other words, the president, without any check whatsoever, could seize and detain them, hold them incommunicado, without counsel, deport them if he chose without a hearing, all of which could easily be read into the vague words, direct the conduct to be observed toward them. But what happened then? In a time of perceived danger, we had just abolished many of the carefully built-in restraints that had been subject to the Constitutional Convention, and for which Madison and others, particularly Madison, had caucused and lobbied. These restraints were carefully crafted and built into the Fifth and Sixth Amendments of the Bill of Rights, only 7 years before. These rights, together with habeas corpus from the body of the original Constitution, were literally wiped out in one quick stroke of the pen during congressional paranoia about the French and other aliens in one hot summer week in Philadelphia. Congress was chafing to get out of town. In short, we had created an underclass, aliens, all aliens, not just French and Irish aliens. We shall review similar instances in our history throughout the remainder of these sessions, including some striking parallels in other executive orders. Now, the Sedition Act, in short order, followed. It was, of course, aimed at the press in particular. Sedition, in the mind of the proponent of the bill, Robert Harper, is merely a special type of libel aimed at the government rather than an individual. So Harper's now infamous legislation provided that if any person shall write, print, utter, or publish, or assist in the same, any false, scandalous, and malicious writing against the government of the United States with intent to defame the government, either House of Congress or the President, or to bring them into contempt or disrepute, or excite against them the hatred of the good people of the United States, or to stir up sedition, such person shall be punished by a fine of up to $2,000 and imprisonment of up to 2 years. In order to pass the legislation quickly, Harper made certain concessions. He provided for jury trial under the direction of the court for truth as a defense. Now, those of you who are lawyers know that truth is a defense to libel. In a stroke, Congress had, of course, essentially nullified freedom of speech and press, but its action had pointed up a major flaw in our constitutional structure at the time. For which branch of government had the right to set aside this hastily enacted legislation? If Congress ran amok, the only check provided lay in the executive veto at that time. But if the executive was compliant with the legislative initiative brazenly violating constitutional rights, as it was here, the checks and balances were essentially ineffective to break our slide into the abyss. Now, this flaw in the system was not rectified until several years later when, as you know, and we discussed last week, John Marshall, as Chief Justice of the Supreme Court, essentially arrogated to the Supreme Court the right to determine whether or not congressional legislation was constitutional in the landmark case, Marbury versus Madison. But in 1798, when Congress provided vague standards for the imprisonment of writers and the apprehension of restraint of aliens, all of whom could, by proclamation of the President acting alone, without any check or balance, be imprisoned, detained, deported, casting aside any semblance of First Amendment freedoms, there was no one, and certainly no branch of government, to say him nay. As Justice Keith of the Sixth Circuit Court of Appeals in Ohio eloquently pointed out only weeks ago, democracy dies behind closed doors. The Alien Act closed these doors just 7 years after the passage of the Bill of Rights. Now, Jefferson, who was then vice president at the time, was so upset that he refused to remain in Philadelphia for the signing of the Alien Sedition Acts. He left for Virginia. Adams had not proposed the acts. His Federalist Party had. Although he had not lobbied actively for their passage, he did not hesitate to sign them into law. This is the same John Adams who had worked side by side with Jefferson in the committee which brought us the Declaration of Independence. Perhaps even more ironic, this is the same John Adams who single-handedly wrote the Constitution of the Commonwealth of Massachusetts, a constitution that to this day stands as a model of individual rights and freedoms and is one of the great enduring documents of the American Revolution. The Constitution of the Commonwealth of Massachusetts is the oldest functioning written constitution in the world. Not only is it founded on the principle of the separation of balance of powers, but it declares in a single sentence that the legislative, executive, and judicial shall be placed in separate departments to the end that the Commonwealth might be a government of laws, not men. It is also ironic that Adams was essentially ahead of his time in 1779 when he drafted the Constitution. The document he drafted single-handedly was truly a precursor and a model for the delicate but lasting balance achieved in our federal Constitution. Yet here, less than 20 years later, Adams, serving now as chief executive in a time of perceived crisis, put yourself in his place, signed into law 2 acts virtually erasing any semblance of the checks and balances that he had written into the Constitution of the Commonwealth of Massachusetts, literally obliterating not only due process and habeas corpus, but freedom of speech and press as well. The Sedition Act had one saving grace, a sunset provision. By its terms, it expired in 2 years. But what happened during those 2 years was enough to do severe damage to our freedoms. But what happened next? Madison and Jefferson acted quickly to nullify the effect of the acts in the states of Virginia and Kentucky. By resolutions passed in October 1798 in Virginia and in December 1799 in Kentucky, the state legislators not only nullified the Alien Sedition Acts in their respective states, but denounced them, declaring them by proclamation, quote, unconstitutional laws of the United States and, quote, obnoxious laws. Now, if only they'd had the Supreme Court to back them up at the time. The ability of these states to override the federal acts, however, was soon tested. The election of 1800 was approaching. Jefferson, Adams vice president, was planning to run against Adams. James Callender, with Jefferson's quiet encouragement and active promises of support, determined to speak his mind and risk prosecution for sedition under the acts. So he moved to Virginia. Virginia had, after all, passed a resolution condemning these acts as obnoxious laws. What happened? Well, he wrote and published a book entitled The Prospect Before Us, in which his writings, which he thought were protected by the Virginia resolutions, vilified Adams and the federal government. The book contains, among others, choice nuggets such as the following, quote, the reign of Mr. Adams has been one continued tempest of malignant passions. The grand object of his administration has been to calumniate and destroy every man who differs from his opinion. It goes on. Washington and Adams are poltroons who raise an effective yelp against the corruption of the French Directory, as if any corruption would be more venal, more notorious, more execrated than their own. Poltroons, by the way, is another word for coward. You'll choose in this election, Callender went on, between a hoary-headed incendiary who has deserted and reversed all of his principles, Adams, and the man whose predictions have been converted into history, Jefferson. Take your choice, then, between Adams, war and beggary, and Jefferson, peace and competency. Let us, by one grand effort, snatch our country from that bottomless vortex of corruption and perdition which yawned before us. Wow. Let's face it, this man was colorful, and he could write. And his book sold very, very well. But poor Callender paid a stiff price. Hamilton, an avowed Callender hater and with good cause, writing again under the pseudonym Marcellus in the New York Spectator, denounced Callender's book as falsehood, sedition, and calumny. The courts soon took the lead. Now, Samuel Chase, was a signer of the Declaration of Independence and a man who had led an attack on the British public offices to protest the Stamp Act. He was now a justice of the Supreme Court, was actually flattered to be called the hanging judge. Now, sedition was not a hanging offense, but Chase felt that a severe application of the Sedition Act was needed, if only to stem the tide of disorder before it swept the country and destroyed our fledgling Union. Although Callender thought he had found sanctuary in Virginia, far from the reach of the federal authorities, he was wrong. Chase, traveling circuit, came to Virginia, had him arrested, charged him with sedition, and brought him to trial there before a jury of 12 Federalists, who dutifully convicted Callender of sedition. So much for states' rights, so much for jury trials. Virginia, in violation of its own resolutions condemning the sedition laws, had just allowed a Federalist judge with a Federalist prosecutor and a Federalist jury to come in and try and convict Callender. As for the viability and actual practice of truth as a defense against the charge of sedition, Chase simply ruled that the accused libeler must prove the truth of his libel. So much for the presumption of innocence. When counsel for Callender protested, what Callender actually wrote was avowedly a political opinion, which did not even purport to be fact and could thus not be proven either true nor false, could hardly be sedition. Chase ruled the objection simply irrelevant. In less than 2 hours, the jury rendered a verdict of guilty and Callender was sentenced to serve time in Richmond jail until March 4th, 1801, when the act would expire, 9 months, pay a fine of $200. Callender had a family to support. This was severe punishment as it rendered them destitute. Well, this then was the Sedition Act in action. Consider this phenomenon brought to fruition by the act in a presidential election. To bring the incumbent president into disrepute was made a crime punishable with fine and imprisonment. If you apply this principle to any federal election, how far are we from fascism? Our basic system of free elections had been subverted virtually overnight. Freedom was indeed on the edge. And it was brought to the edge by some of the very men, such as Adams, who had been the heroes of the revolution, men who put their lives and their fortunes on the line for freedom. They'd subverted it all in the blink of an eye. All this in a time of perceived national crisis. But again, Adams was no longer in the area of theory. He was in control of a country. And he was concerned the country would be attacked. Well, what happened after that? Well, British Admiral Horatio Nelson decimated the French fleet at Trafalgar off the coast of Africa, and by 1800, the entire threat of invasion by the French had abated. George Washington, who was reluctantly pressed into service by Adams, retired, leaving the army to the feared Hamilton. Fortunately, Congress significantly reduced the budgetary allotments for Hamilton's army, and thus the threat of his invading the southern territories held by Spain evaporated, much to the relief of the nation. Jefferson won in a hotly contested presidential election of 1800, which was decided in the House of Representatives, an election which was swung by the vote of none other than Matt Lyon of Vermont. Now, he was now known as Spittin' Matt Lyon. Lyon had himself been imprisoned in Vermont for 4 months under the Sedition Act, not long before. His crime was describing Adams as swallowed up in a continual grasp for power, in an unbounded thirst for ridiculous pomp, adulation, and selfish avarice. One of the complaints about Adams, you may know, is they were concerned he would be a monarchist. Hamilton, by the way, was the kingmaker in this election, actually causing the vote to go against his own Federalist Party to prevent the election of his hated rival Aaron Burr as president. Burr, as you know, came in second, was elected vice president, eventually killed Hamilton in a duel. James Callender was pardoned by Jefferson as one of Jefferson's first acts in office, as were all those, such as Matt Lyon, who had been convicted under the Sedition Act. Callender, however, felt that he was shabbily treated by Jefferson, and it became Callender who in fact first exposed Jefferson's notorious affair with his slave, Sally Hemings, one of those another curious irony of history. The Sedition Act expired in 1801, was not extended. Jefferson would have none of it. We were not to have another Sedition Act till the spring of 1918, when Congress amended the Espionage Act of 1917 These amendments, which were referred to as the Sedition Act, were repealed in 1921, following the notorious Palmer raids. We'll get into that later. So we escaped from the edge only narrowly, and some very serious precedents had been set. Precedents which we'll see have had striking consequences at various times in our history, well into the 20th century, and in fact, right up to the present. Now, the right of habeas corpus is not part of the Bill of Rights, as we all know. As you may recall from last week, it's referred to only once in the Constitution. That's in Article 1, Section 9, which refers to it as a privilege which shall not be suspended unless in cases of rebellion or invasion the public safety may require it. That is in a section dealing with congressional, not executive power. Although it's not part of the Bill of Rights, however, habeas corpus is perhaps the most indispensable of all of our civil rights. For suspension of the writ renders the courts virtually powerless to release persons who are held in violation of other protections of the Constitution, which brings us to the year 1861. Nowhere in our history were the conflicting demands of freedom and order so highlighted as during our Civil War. Perhaps nowhere in our history has the inherent conflict between the judiciary and executive branches been brought more starkly into focus. Abraham Lincoln was first elected to office in November 1860, but they weren't inaugurated in those days till March. He delivered his inaugural address on March 4th, 1861. Only 6 weeks later, on April 14th, 1861, Fort Sumter was fired upon. April 19th, a mob in Baltimore blocked the passage of Massachusetts troops on the way to guard Washington. That night, local authorities in Baltimore burned Baltimore's key railroad bridges. They claimed that their action was prompted by the fear that Northern troops might seek revenge for the riot. Moreover, the governor of Maryland had called a special session of the legislature to convene on August 26th. If Maryland voted to secede, Washington faced permanent isolation from the rest of the Union. Just think of the geography here for a moment. You've got the North, you've got Maryland, and you've got D.C. Washington is blocked. The Union's cut off. Lincoln, just a 6-week neophyte in office, was being given a terrifying reality check. The game had only just begun. Lincoln was about to be checkmated. If something drastic were not done immediately, the Union would be cut in half. Lincoln's general-in-chief, Winfield Scott, was of mind simply arrest any secessionist-minded politician, put him in jail. But Lincoln would not allow it. In a letter of April 25th, he admonished Scott to hold off from any such action. But in the same letter, in language he struggled through many drafts to finalize, Lincoln reluctantly authorized Scott, in the event the people were armed against the United States, to adopt, quote, listen to this sequence, efficient means to counteract, even if necessary to the bombardment of their cities, and in the extremest necessity, the suspension of the writ of habeas corpus. Think of the juxtaposition. The juxtaposition of these two remedies of bombardment and suspension of habeas corpus may give us some idea of the reverence in which Lincoln held the writ of habeas corpus at this earliest date in the war. Bombardment of the cities, but that's not the extremist remedy. The extremist remedy was the writ. Try bombardment first, and if that doesn't work, then the writ. Well, some historians have concluded this simply conveys this confusion at the time. But either way, this letter to Scott constituted the first suspension of the writ by Lincoln, and it proved to be the first of many. Was there precedent for this, legal or otherwise, in our history? After all, we hadn't had a civil war before. A digest of case precedents handed to Lincoln was no help. To the contrary, it obtained an opinion of Justice Story of the Supreme Court that only Congress could suspend the writ. Remember where the suspension of the writ comes, Article 1. The constitutional power, after all, appears only in Article 1, which deals with the powers of the legislative, not the executive branch. Nor was Lincoln experienced in such issues. In his Pulitzer Prize-winning book on the subject, entitled The Fate of Liberty, and subtitled Abraham Lincoln and Civil Liberties, Historian Mark Neely, Jr. points out that questions concerning martial law and suspending the writ of habeas corpus were hardly likely to arise from the ordinary practice of a yeoman lawyer in Illinois, which Lincoln was. In point of fact, Neely goes on, Lincoln probably learned more on this subject of political history than from his law books. Good old Andrew Jackson, Old Hickory, had imposed martial law in the city of New Orleans during the War of 1812. And having done so, proceeded not only to ignore a writ of habeas corpus, but to arrest the poor judge who'd had the misfortune to issue it. Well, that was Andy Jackson. Such forceful episodes as these were very much on Lincoln's mind. He grudgingly admired Jackson's forcefulness, the willingness to take command during danger, and to do something. Washington, our capital city, was fearful. The rest of the Union was angry at the insult of a Baltimore mob and the bridge-burning city fathers. Lincoln's staff was exploring alternate means of bringing the troops through to defend the capital, but from the accounts of his private secretaries, John Hay and John Nicolay, this period unnerved Lincoln. They report that by nature and habit, Lincoln was calm, equable, undemonstrative. The president paced the floor, then stopped and gazed wistfully out the window, down the Potomac, in the direction of the expected ships, with irrepressible anguish. Why don't they come? Why don't they come? 2 days later, in fact, troops arrived. By train, people rejoiced. But Lincoln nonetheless suspended the writ. Scott remained convinced that an attack on Washington was imminent, as only 1,600 volunteers had arrived from Massachusetts, and the Confederates had amassed 8,000 troops at Harper's Ferry. Well, Lincoln confined the suspension to a very narrow geographical area at that time, along the vicinity of the military line between Philadelphia and the city of Washington via Perryville, Annapolis City, and Annapolis Junction. The letter to Scott was never publicized. It was not a public proclamation. No one informed the courts or other civil authorities. Scott merely assumed that he could delegate the authority to others, and he did plentifully. The court, however, soon learned of the suspension when an officer refused to comply with a writ issued by Justice Taney. Now, the court almost immediately challenged Lincoln in the case of John Merryman, a citizen accused of drilling Marylanders in a conspiracy to take them south to join the Confederacy. Taney, whose sympathies were pro-South and pro-slave owner, was the author of the notorious Dred Scott decision. He had issued a writ to free Merryman, but the arresting officer, relying on the president's order, had simply ignored the writ. Well, Taney was furious. He wrote an opinion challenging the legality of the president as opposed to Congress suspending the writ, calling this sarcastically a constitutional point of law upon which there was not a difference of opinion. Oh, but of course there was. Taney and his opinion was simply ignored by Lincoln. So much for the judicial check on the executive during times of emergency or rebellion. With respect to this case and other criticism of Lincoln, author Mark Neely observes, Lincoln would eventually answer theory with theory, but he would act as needed in the meantime. Like Adams, theory for theory, act as needed. Let me focus on this last observation for a minute. For Lincoln, we have one of the most gentle and humane presidents in the history of our nation. One who is so revered in our society that his visage is carved in stone on Mount Rushmore. His memorial in Washington is for many a sacred place. A place where Marian Anderson, for example, chose to sing America when she was denied access to the concert hall by the Daughters of the American Revolution. A place that Martin Luther King Jr. chose to deliver his I Have a Dream speech. And where even Richard Nixon, hoping for inspiration and divine guidance, wandered alone and virtually unprotected at 2 a.m. of a sleepless night, much to the horror of Bob Haldeman and the Secret Service, and engaged in a spirited dialogue with a hostile group of young Vietnam protesters. It is a place that has become synonymous with an almost sacred respect for the dignity of the human soul. So revered is Abraham Lincoln to our people. And yet here is that same almost saintly Lincoln, faced with the peril of disunity, and faced also with the potential disintegration and destruction of the Union, within weeks of his taking office, essentially saying, to paraphrase Neely, action is needed, not theory. Act first. Suspend rights if that's what's needed to save the Union. Theory will take care of itself in due time. How did Lincoln justify this? Terrible, terrible, tough issue. At a special session of Congress called July 4th, 1861, Lincoln did not contradict Tawney's theory that only Congress had the power to suspend habeas corpus, but contended that he had only done in an emergency what Congress would ratify in any event. Many have deemed this sophistry, of course, because who knows what Congress would have done if they would actually have been able to assemble. But it had a certain compelling quality to it, for he continued, "It cannot be believed that the framers of the instrument intended that in every case of rebellion or invasion, the damage should run its course until Congress should be called together, the very assembling of which might be prevented, as it was intended, in this case by rebellion." Lincoln then labored with the proposition in Merryman that one who is sworn to uphold the laws should not himself violate them. Now his rejoinder was this, and it's become famous. State the question more directly. Are all the laws but one to go unexecuted? In other words, all the laws but habeas corpus. Are all the laws but one to go unexecuted, and the government itself to go to pieces, lest that one be violated? Even in such a case, contended Lincoln, would not the official oath be broken if the government should be overthrown when it was believed that disregarding the single law would tend to preserve the government? But then, as if taken aback by the brazenness of what he just said, Lincoln decided he really didn't want to go there. And he quickly shrank from embracing this bold theory by continuing, but it was not believed that this question was really presented. It was not believed the law was violated. In other words, he was only doing what Congress would have done anyway in suspending the writ if they'd been physically able to convene. Lincoln biographer James Randall has concluded from this address to Congress that Lincoln was deeply troubled by the appearance of military dictatorship, and that few measures of the Lincoln administration were adopted with such reluctance as this. Neely, however, concludes somewhat differently that the speech is the work of a fledgling president, uncertain of his legal ground and his proper audience, nervous and at once candid and too forthcoming. Lincoln would learn fast, according to Neely, but he had not mastered the job by July 1861. Personally, I see a deeply troubled humanitarian, one who is about to become hardened but never callous about human life. I see him struggling mightily with the precarious balance of freedom and order, and I see him seeking any plausible rationale he can find to justify acts by the executive on its own, without congressional sanction, in order to preserve the Union. Suffice it to say that the writ was suspended on hundreds of occasions thereafter during the war, and Lincoln would eventually even delegate the writing of the orders and proclamations suspending it. Other leaders, such as Richard Nixon, have labored to compare themselves to Lincoln, arguing that if Lincoln could suspend habeas corpus in times of national crisis, why couldn't they bend lesser laws, such as the Fourth Amendment prohibition against unreasonable searches and seizures, to protect the country's security during, say, the Vietnam crisis? David Gergen, who worked in the Nixon White House, feels that such an analogy is too much of a stretch. He says, Lincoln limited his suspension of rights, which he did, acted openly, which he did, and promised to restore full liberties upon the conclusion of the war. Nixon set no apparent limits, acted surreptitiously, and set in motion various illegal acts that were increasingly disconnected from the war. For example, so-called black bag operations, dirty tricks and political opponents having nothing to do with the conduct of the war. To me, the comparison of Nixon by himself to Lincoln, however, is so odious that I found even more profound differences. And I'll return to this subject when we consider the dark, enigmatic Nixon and Watergate in our fifth session. Nevertheless, the suspension of rights during periods of national crisis in order to preserve national security remains a critical issue. And we come now to the year 1863. Civil War was in full swing. On March 3, 1863, Congress finally passed the Habeas Corpus Act, granting legislative approval to executive suspension of the writ. But on the same date, Congress also passed the Conscription Act. Now, conscription is a euphemism for draft. The Union was running short of manpower. Domestic violence erupted after that act was enacted. The draft riots in New York on July 11, 1863 were fierce. They've been described as the greatest incidents of domestic violence in all of American history. The issuance of writs of habeas corpus by state courts now to free draftees were pulled in. Bring them out was becoming a commonplace occurrence and was threatening the conduct of the war. Lincoln was furious. This was a gross distortion of the power to issue writs, and it imperiled the Union. On September 15, 1863, he issued an order provided that since the Constitution ordained that the writ may be suspended in times of invasion or rebellion, and since we were in a state of rebellion, the President was suspending the writ throughout the land, now no longer limited, for a rather comprehensive list of offenses, including detention of spies, aiders, and abettors of the enemy, deserters from the armed forces, and draft resistors or other offenders against the laws of the military. Mark Milley points out that questions of legal and constitutional form still took a back seat in the Lincoln administration. Actually, the order as it finally emerged and was signed by Lincoln was a modification of the original draft by Lincoln, which had been presented to the cabinet by Lincoln himself. What is significant is that Lincoln's initial draft of this order actually contemplated the use of armed force by the executive against officers of the courts attempting to enforce judicial writs. Mark Neely concludes, Lincoln's directive seemed to raise the specter of armed conflict between the two branches of government. Perhaps nowhere in our history is the inherent conflict between the branches of government, which the founders attempted to balance perilously, been brought more sharply into focus than here. Lincoln had a war to win to preserve the Union. The exigencies of the office required him to suspend the writ. Now, there's no doubt that Congress had authorized Lincoln to authorize the military to arrest one Lambton Milligan on October 5, 1864. But it did not authorize the military to try Milligan, a civilian, before a military commission. Now, Milligan was a civilian, a resident of Indiana. He was accused, tried, convicted, sentenced by a military tribunal to death by hanging. His crime was involvement with the Sons of Liberty. Now, this was an admittedly disloyal organization. The Supreme Court ultimately reversed the decision after the Civil War was over and freed Milligan. It held that martial law and military trials of civilians in the United States were illegal whenever civilian courts existed and were open and functioning, as they were in Indiana at the time of Milligan's arrest and detention. The Milligan decision, by the way, did not preclude the arrest, detention, and close confinement of Milligan, but only the trial by a military tribunal where civilian courts existed. One memorable quote from Milligan case is this: "No doctrine involving more pernicious consequences was ever invented by the wit of man than that any of the Constitution's provisions can be suspended during any of the great exigencies of government. Such doctrine leads directly to despotism." Strong quotable language, and there were numerous other eminently quotable lines in Milligan. It was a very, very long decision. Now we'll return to a discussion of this precedent again when we consider our current attempts to utilize military tribunals. Suffice to say, ex parte Milligan is one of the most quoted cases in the history of the Supreme Court. But does this mean that we can look to the court as the ultimate check on the power of the executive in times of national crisis? Well, Alan Dershowitz, in his book Shouting Fire, states emphatically no. Like most such court opinions, it commonly happens, argues Dershowitz, when the emergency is over, and when the court and we have the luxury of viewing exigencies such as this in hindsight. There are many examples of that. Case of Duncan versus Kahanamoku in the Second World War, basically a ruling by the Supreme Court, but decided in 1946 that the declaration of martial law in Hawaii had been illegal. but it happened after the war. Notwithstanding Milligan and the fact that when it was finally decided the exigencies of war were over, trials by military tribunal continued until 1870, especially in the South as we entered the period of Reconstruction. From this and numerous other precedents, both Dershowitz and Professor Lawrence Tribe of Harvard Law School have despaired of the Supreme Court's performance of its intended role in the separation of powers in times of national crisis. Both have concluded that the court simply will not interfere with the executive's handling of a genuine emergency. They have both concluded that, regrettably, the judiciary will employ every technique of judicial avoidance at its disposal to postpone a decision until a crisis has passed. In an article last December in the New Republic, Lawrence Tribe lamented, "Historically, the judiciary has been so deferential to the executive in wartime as to provide virtually no meaningful check. It would be a terrible mistake for those who worry about civil rights and liberties to pin too much hope on the judiciary in times of crisis." Now, we'll return to this observation when we consider the Quirin, Hirabayashi, Korematsu decisions by the Supreme Court, which happened during World War II. Unfortunately, as we'll see, ex parte Milligan, although oft-quoted, has just not been followed as judicial precedent, at least not in times of stress or national emergency. In 1998, Chief Justice William Rehnquist authored a book with the significant title, All the Laws But One, Civil Liberties in Wartime. The title, of course, paraphrases Lincoln's remarks in defense of the suspension of the writ. It's a well-written book, incidentally. It's a well-written historical review of the suspension of habeas corpus during Lincoln's time and of treatment of civil liberties during times of national crisis and thereafter. And it may give you some idea of the disposition of the Chief Justice in this regard. I commend the book to all of you to read, to give you some idea of the mentality of the Chief Justice in this issue. It ends with the following significant closing lines. Quote, "It's neither desirable nor is it remotely likely that civil liberty will occupy as favored a position in wartime as it does in peacetime. But it is both desirable and likely that more careful attention will be paid by the courts to the basis for the government's claims of necessity as a basis for curtailing liberty. The laws will not be silent in times of war, but they will speak with a somewhat different voice." On June 14th of this year, Rehnquist addressed a judicial conference of the United States Court of Appeals for the District of Columbia. It's been reported that at that conference, Rehnquist remarked that at times of war, the courts defer to whatever the executive branch asks of them. Pretty much what Dershowitz and Tribe seem to be saying. But I'm not sure that's the total conclusion, the last line of his book. That attention will be paid by the courts to the basis for the government's claims of necessity. Well, at least not the lower courts, not now, not so far. Numerous initiatives by Attorney General Ashcroft under the USA Patriots Act and otherwise have been challenged in decisions of the lower courts. But if Rehnquist's remarks are any indication, these decisions may face rough sledding when and if they reach the High Court. Now, except for one motion for a temporary stay, the Supreme Court so far has not yet weighed in on this. This summer, on June 13th, the Supreme Court did grant an appeal by the Justice Department for a temporary stay of rulings by the Third Circuit and the trial court, which would have opened a detainee's immigration proceeding to the press. Now, the case is back in the Court of Appeals with a temporary stay, and it's closed. And the constitutionality of the so-called CREPI regulations, which were issued by the executive, by the chief immigration judge, closing all so-called special interest, terror-related immigration hearings without any opportunity for assessing on a case-by-case basis whether as a matter of national security closure is truly necessary, was argued there only 2 weeks ago. It's a North Jersey media case, if any of you want to look it up. Legal argued it for the ACLU, and the Justice Department argued for the government. The issue may well reach the Supreme Court in the not-too-distant future. It may not. They may not grant certiorari. I have a feeling they will. The Supreme Court's ruling granting a stay, temporarily closing the hearing, may be an indication that no matter what the lower courts do, the Supreme Court will ultimately bend to the executive branch in wartime. Or, for all we know, the court and Rehnquist himself may determine that the government has not shown the requisite necessity for closure in this instance. The issues are complex. There are no absolutes in weighing of the conflicting demands of freedom and security. Remember what happened during the time of Adams, the time of Lincoln? We'll have to watch this phenomenon as it plays out in the months and years ahead. My intention here is to alert you as to what's gone before and to what to look for in the months and years ahead in this regard. So we've explored at least three of our recurring themes today. The effect of national emergency, as in the case of the Civil War, and the combination of a perceived threat of national emergency and xenophobia, as in the case of the French invasion of 1798. These factors led to a vitiation of the First Amendment rights of freedom of speech and press and the constitutional rights of habeas corpus. We've considered the effect of the imbalance in the separation of powers on these rights, particularly where the balance is weighed in favor of the executive. And we've seen how these factors have led to the incursion on our freedoms during the presidencies of two otherwise humane leaders, John Adams and Abraham Lincoln, men surely respectful of the dignity of their individual constituents. The atmosphere which pervaded the passage of such legislation as the Alien Sedition Act and the Habeas Corpus Act has a tendency to repeat itself during times of crisis and xenophobia. Numerous alien acts, beginning as a reaction to the assassination of President McKinley in 1901 by an avowed anarchist, culminated in the Espionage Act of 1917 during the First World War and the amendment thereto known as the Sedition Act of 1918. That in turn paved the way for the shameful Palmer raids and the witch hunts in 1920. Xenophobia generated out of the populist movement of the late 19th and early 20th centuries, coupled with severe economic crisis of the 30s, was fertile breeding ground for charismatic demagogues such as Huey Long, Father Charles Coughlin, and Martin Dies. We'll examine that next week. And we can trace many of these same xenophobic elements in the internment of the Japanese Americans in 1942, following Pearl Harbor, the growth of the House Un-American Activities Committee, the McCarthy witch hunts of the early 1950s, and the paranoia against opposition to national policy we experienced during the Nixon White House in the 1970s. All of these developments bear the toxins of 1798 and the 1860s. These latter events were not elements in the fabric of our social and political history which materialized out of thin air. These are all events we'll consider here. The contradictory demands of freedom and order are inevitably highlighted during times of xenophobia and during threats or perceived threats to our nation in times of national stress or peril. These conditions often lead to the adoption of measures such as those we consider today, which cause a perilous imbalance in the separation of powers and a necessity place in jeopardy the personal freedoms established in the Constitution and the Bill of Rights. Whether or not Chief Justice Rehnquist's interesting historical perspective and his recent remarks on the role of the court in issues in times of war will serve to highlight this perilous imbalance in the immediate future is something we'll be watching closely in the months ahead as a myriad of cases wend their way up to the Supreme Court. The result is by no means a certainty. The more we study our political history in depth, and the better we understand these ever-present elements in our political climate, the better we will be able, I hope, to assess these issues as our democratic society struggles mightily to find the right balance as it defends itself simultaneously against both the terrorist onslaught and the assaults on our personal freedoms. Next week, we'll get into populism and its heirs apparent in the Depression, Huey Long, Father Charles Coughlin, Martin Dies, and beyond. Thank you.